Hey everybody, this is Robert from Blue Summit. Welcome to our webinar today titled Protecting Your Loved Ones with Mandie Bullock and Judy Seid. So we are now going to get started, and I'd just like to first introduce myself. I am a partner at Blue Summit Wealth Management, and I focus in financial planning and sustainable investing for our clients. So I just wanted to first go over some house rules for today before I introduce our topics and our speakers. So first of all, at the bottom of your screen, whether you're using a computer or a smartphone, you should see a Q&A button as well as a raise hand button. So either of those ways or a chat button. So those are three ways that you can interact with me. I will be the administrator of this webinar and can answer any questions that you have during the webinar. The schedule for today will be 30 minutes of presentation, and then we'll have 5 to 10 minutes of Q&A at the end. And if you have any questions along the way that we can't address on the webinar, we can address them offline. So we will be sure to track these and follow up with you. So don't worry if it doesn't get addressed now, we'll be sure to follow up with you. So the title of our webinar today is Protecting Your Loved Ones. And this is going to be full of insights on such topics as trusts and wills, protecting the next generation, naming beneficiaries, life insurance, long-term care insurance, and avoiding possible inheritance or estate taxes. So I'd like to introduce our speakers now. Mandie has been an attorney for 12 years, and her focus is estate planning and protecting the next generation. She is passionate about helping families create happy and secure futures. In her spare time, she enjoys yoga, mountain biking, and exploring the outdoors with her family. Judy is the founder and a partner at Blue Summit and a licensed certified financial planner. She has been helping people make good decisions with their money for nearly 30 years and has specialized in sustainable and responsible investments for that entire time. In her spare time, Judy likes to cycle and enjoys backpacking in the Sierras. So without further ado, let's get started, and I'll first pass it off to Mandie.
Thanks, Robert. And thank you all for being here. Yeah, congratulations for showing up for this. I know it is not the most easy topic to think about, but you might say that fully embracing death is a key to happiness and a rite of passage. So let's toast to a long and healthy life. So like Robbie said, I've been a lawyer for 12 years. I have a wonderful husband and 2 little boys. I just wanted to tell you a quick story that reinforced for me again why estate planning is so important. My mom passed away 8 years ago with no estate plan in place. She had no will, no trust. It was something she had been meaning to do, and she needed to have a trust, but she put it off. And once she became sick, it was too hard for her to think about at that time. And it never got done. So my brother and I had to deal with probate, which is the court process. More about that later, but we had to deal with that. And this was in New Jersey, which is supposed to be a probate-friendly state. It's supposed to be quicker and cheaper there, but it ended up taking over 2.5 years and thousands and thousands of dollars. But the worst part was the emotional toll it took on our family and my brother and I. And she could have avoided a lot of that with a trust. She could have named a trustee who was a little removed from the family, who could have distributed her assets, outside of my brother and I having to deal with it. And we could have been grieving together and not dealing with court and all that bureaucracy and headache. So yeah, that just was kind of a firsthand account with it. And I just want to help everyone avoid that for their families. And then, yeah, just having my own kids was just another kind of wake-up call, again, why this is important. Just having them, I realized this is something you do for your kids, and I'll get more into how I kind of took it a step further in protecting young kids. All right. So when was the last time you reviewed your existing estate plan? Or if you don't have a plan, then what is the state's plan for you? So a typical estate planning experience is a one-time transaction. You get form documents, which may help you avoid probate, may not, may avoid estate taxes, might not, and that it would leave assets to your heirs unprotected. You'd have no ongoing legal guidance, and you could potentially, your heirs could lose your assets to the State Department of Unclaimed Property. So yeah, when I first started doing estate planning, I was working at a firm, kind of doing estate planning the normal way. So meeting with my clients twice, the first meeting and then the signing meeting. And then most attorneys don't really have any more contact with their clients throughout their lives. And meanwhile, their lives change, their guardian choices are outdated, the estate tax laws change, they acquire new property. So I always had this feeling that their plan might not work when it needs to. So when I went out on my own, I really wanted to make sure I keep up with my clients throughout their lives and make sure that everything's up to date and will work when it needs to. So let's see. So in contrast, the way I do things, it's kind of different than most estate planning attorneys. So I help you make informed, empowered decisions. I'll help you save your family thousands of dollars. Your assets won't be lost upon your death, and your estate plan will protect your assets from outsiders. Yeah, I'll keep you, make sure that you are making the right legal financial choices, keeping your family out of court and conflict, and making sure that it all works when it needs to. So yeah, by going through this process, you'll become more financially organized than you've ever been. And yeah, just you'll feel empowered, and you'll know that you're making all the best decisions for your family, and it's not a one-size-fits-all plan. It's totally custom and will absolutely work for your family. So I will turn it over to Judy now, and then I will be back.
Hey, Judy, I think you're muted. We cannot hear you.
There we go.
That's
How's
a lot
that?
better, much better.
Thank you. I did do that once before. Hi, everybody. Thanks for joining us today for our workshop on estate planning. And thank you, Mandie, for all the great start. And I know she has much more. So I'm just going to dive into my part of the presentation. You're going to see here that I've got 5 topics to present to you in our short time together today. The first one is going to be a quick overview of risk management in regards to life insurance and long-term care insurance. The second topic is going to be avoiding inheritance and estate taxes. The third is planning for a fiduciary. The fourth is making your beneficiary designations. And the fifth is assembling your financial team. So I'm going to talk first about some risk management. Obviously, risk management entails much more than just life insurance and long-term care insurance. Everybody's got car insurance, homeowners insurance if you own a home, property insurance for your boat, an airplane. I mean, I don't have an airplane, but if you have an airplane, you would need that. But life insurance is so important to protect your family. We're going to talk about that for a few minutes, and then about the long-term care insurance also for a few minutes. So the first thing to know about life insurance is that is a very important insurance policy to have if you need it. If you don't need it, well, you can get rid of it and save money. A lot of people have unneeded life insurance policies. There's a lot of salespeople out there that would love to sell you a life insurance policy, even if you don't need it. So how do we know if we need life insurance? It's pretty simple. If you were not to walk in the door one day from work because you met an untimely death, would somebody suffer because your paycheck no longer came in? Do you have dependents who rely on your income? That's the number one question. Do you have children who you are supporting? Do you have a spouse who you are helping support? Do you have a parent who you are helping support? So if somebody relies on your income, the income that you generate from working, then you should probably either have or consider a life insurance policy. The next question is, how much life insurance should you have? That's a little more complicated. And so you're going to see on my presentation here that I suggest you calculate all of your financial obligations. You take your salary, which is, what you're bringing home, times the number of years you're going to want to replace that income. So if you were planning to work for another 10 years and then you were going to have enough other resources to fund your retirement and your beneficiaries' needs, then we'd want to make that calculation. Then you're going to want to add in your mortgage balance. And sometimes people will get a life insurance policy that simply is for the amount of the mortgage, to pay the mortgage off if that's all that they feel they need to protect their beneficiary. Any other debts you want to add in, any other future needs. So if you've got kids that you're planning to put through college and you were going to fund that through your income, then you'd want to add that in. And if you're a stay-at-home parent, you're going to want to add in the cost to replace the services that you provide. So if your spouse loses you and you've been taking care of those kids, well, all of a sudden he or she is going to have to hire a nanny. And that's going to be an additional cost over and above what your living expenses currently are. So, from that, you can subtract your existing assets. So that's a simplified way of looking at life insurance needs analysis. We actually do a more complex version of that, but that will at least get you a start. And then, of course, I suggest that you speak with a financial advisor and get some help. So moving on to long-term care insurance. Long-term care insurance is a form of health insurance that picks up where your health insurance, your HMO or PPO, ends. Normally, if you need some kind of health care, and let's say you have an accident or an illness, you call upon your normal health insurance like Kaiser or Sharp here in San Diego to be able to go for your outpatient needs, for your acute care if you had an injury, for your hospitalized care if you have a surgery or anything like that. But once you are released from the hospital, if you're not going to fully recover, or if you just get old and can't take care of yourself and you never even went to a hospital, all of a sudden you need something that we call long-term care. It's for a longer period than just acute care or rehab. It's for a longer period, and that's why they call it long-term care. And it's not covered by your health insurance plans. You may have 30 days. Let's say I think Kaiser might give you 30 days. Medicare does not cover long-term care insurance. They might cover 20 days. But beyond that, you're on your own. If you need to have a care provider come in your home, if you need to go to assisted living, or if you need to go to a nursing home, that's all going to be out of pocket until you run out of money. When you run out of money, yes, you can apply for Medi-Cal in California or Medicaid in other states, which is welfare. You have to be almost completely out of money And then you can apply, and then you would have to be in a Medi-Cal approved facility. It doesn't pay for home care. So if you have any sort of assets, especially if you want to protect those for your family members to be able to inherit, or if you want to protect them for your spouse, if you just want to make sure you have really good care and a quality of life as you age, then you want to cover it with long-term care insurance. It's easy to get a policy if you're healthy. It's not easy to get a policy once you're not healthy anymore. So it's really important to think about this early. I got my long-term care insurance when I was 44 years old. Not everybody does that, but I believe in it. My first clients that I wrote a policy for were my own parents, and that's how I learned about long-term care insurance almost 30 years ago. And so I'm very quickly going to describe the basics of a long-term care policy. And so when does a long-term care policy pay? Well, you're going to see here, you qualify for benefits through the activities of daily living: bathing, dressing, eating, continence, toileting, and transferring. If you can no longer do any two of those activities of daily living, then if you have a policy, it will pay for a care provider to help you with those things. And when we design a policy, we look at 5 different variables: the daily benefit amount, which in California, nursing home average is about $285 a day. So you can get a policy for just part of that. If you want to just cover a part of your risk, maybe $200 a day, or you can cover the full amount. It's obviously just going to be more expensive the more daily benefit you purchase. Then there's the years of care. So you can buy, for example, a 3-year, 4-year, 5-year, sometimes a 6-year policy, depends on the carrier. And those years of care are multiplied times the daily benefit amount to get this pool of money that you have available in your policy. So I've put an example up here on the screen. If you bought $285 a day and you had a 3-year plan, that's 1,095 days. That would give you a $312,000 pool of money that would be available the minute you take your policy out if anything were to happen to you, be it a car accident or aging or dementia. Then every policy you have to choose your elimination period, and that's simply a deductible. And then you can choose an inflation option. You can either have 0 inflation. I don't normally recommend that unless somebody's in their 70s when they're buying the policy. 3%, 5%. Are the other options normally. Some of the carriers have other options, but for example, this $312,000 pool of money, if you had 3% inflation built in and you didn't use the policy for 30 years, you'd then have $757,000 pool of money. If you had 5% inflation, you'd have a $1.3 million pool of money in 30 years. So these policies are really important to secure you in retirement and for your estate planning. There's also a shared care option if you're a married couple or a living together couple with some of the carriers. And so that's my quick overview on long-term care and life insurance. And Mandie, it's your turn to give us some more good stuff.
Thank you, Judy. Very good info. Okay, share my screen here. Okay. Okay, so if you don't have an estate plan in place and you die with no trust, the state has a plan for you if you become incapacitated or die, and it's called going to court. So a judge can appoint someone to make decisions for you and or give your family access to your assets or direct where your assets should go. So this process is called conservatorship if you are incapacitated, or probate if you have died. So the court decides where your money goes, and it may not be to who you would choose or in the amounts that you would choose. And court is costly. So there's attorney's fees, executor's fees, appraiser fees, court filing fees, bond premiums, creditor claims. So yeah, a recent probate I heard about had one piece of real property valued at $1 million, and the attorney's fees alone were almost $30,000. And 22,000 of those fees were statutory fees provided by state law. And then the executor was entitled to another 22,000 in fees. And all of these fees could have been avoided with a few $1,000s spent on a basic foundational estate plan. And then probates take a minimum of 12 to 16 months in California. And during this time, your loved ones may not have access to your assets. And like I say, probate is really a lawsuit you file against yourself with your own money for the benefit of your creditors. So definitely nice to avoid it. So plus the court process is totally public, meaning anyone can go down to the courthouse, pull your court records to see what you own and who is getting it. This is the will of Jackie Onassis Kennedy Onassis, sorry. Would you like to see the will of John Lennon, JFK Jr., Babe Ruth, Jerry Garcia? You could, because they all went through the court process. So my point here is that a will is public and doesn't avoid probate. When a will enters probate, it puts all of the creditors out there on notice that your loved ones will be receiving money. So the only plan that is private, avoids probate, and ensures your children receive your assets when you want and how you want is with a properly funded trust. But we'll talk more about that. All right, back to you, Judy.
All right, thank you, Mandy. So lots of good stuff, and that's a big, important thing. I guess maybe it's just me, but I think a lot of people feel the same way. I wouldn't want my estate planning public information, and by making a trust, it's completely private. That alone is well worth it. The probate fees are ridiculous in California. So if you live in another state, and some of our clients do, it's important that you do talk to an estate planning attorney in your state, because the state rules do differ. I'm going to talk for a few minutes about avoiding inheritance taxes and what you might need to know there. Well, first of all, there is an annual gift amount that you can gift any person per year, and it completely disappears from your estate without having to file anything on your taxes or pay any estate taxes. And that number this year is $15,000 per person per year. In other words, if I had 3 children, and also that 15,000 is for me and my spouse. So let's say I'm married, I can give 15,000. My spouse can give 15,000. If we have 1 child, we could give 30,000 to that child. If we have 6 children, well, we can give 180,000, 15,000 to each child. Or if we have 3 children and they each have a spouse, all of a sudden that's 180,000 we can gift out every year out of our estate. And let's say we have 5 grandchildren on top of that. That would be another 30,000 times 5, or another 150,000. 3 kids, 3 spouses, 5 grandkids, and all of a sudden we're giving away 330,000 if we wish to do so without having to report it. It's completely non-reportable. If you give more than that to any person, then you have to file a gift tax return. It doesn't mean that you're going to pay taxes. It just means you have to start adding it up, and it'll go towards your lifetime exemption amount, which you're going to see down below is 11.4 million right now. When you die, if you die with over 11.4 million, your base tax rate the federal rate is 37%. So 37% of everything over that is taxed, excuse me, it's taxed at a 37% rate plus whatever your state taxes are. And so the gifting can get money out of the estate if you have a fear that it's going to be over that limit. Also, that limit changes. So with every administration, we've seen changes in the estate tax exemption amount. It's higher than it's ever been. When I first started as a financial planner, the estate tax exemption limit was 600,000, less than 1 million. Now it's over 11 million. So this number can change, if Congress decides to change it. So keep that in mind as well. Step-up basis. I want to explain what step-up basis means at inheritance time. So let's say my family member dies and they had a home that they owned, that they maybe bought for $100,000, and now it's worth $1 million. Well, when I inherit it, I get that home at that new basis, at that new valuation of $1 million. So that $900,000 in gain just disappears. If they would have sold it during their lifetime, then they would have had a $900,000 gain to deal with. Maybe some of it would have been taxable. It depends if it was a personal residence, but personal residence or not, when I inherit that property, whether it's stock, real estate, any kind of asset, it gets a step-up basis. It steps right up to the current valuation. And one other thing to know is that life insurance, which we talked about a few minutes ago, is completely tax-free. So when you buy that life insurance policy and your beneficiary gets it upon your death, it's not included as part of the taxable estate. And the other thing that is very important about protecting your inheritance is that if you inherit something, that does not have to be community property with your spouse. And here in California, we're in a community property state. So while you're married, everything that you earn, if it's earned income, is considered joint property. Everything you accumulate in your 401k or your IRAs during your marriage is considered joint property. However, your inheritance is not considered community property unless you commingle that with other assets. So you need to be careful. If you get an inheritance, the best thing you can do is visit a financial planner. Let us help you. Let us direct you on how to be careful with that inheritance. You don't want to commingle and you don't want to transmutate. And you can also use an asset protection trust, which somebody like Mandy can help you with. So protecting your inheritance, hopefully, that's enough to get you started. Mandy, I'm going to turn it back to you.
Thanks, Judy. All right. Thank you. Okay, and then right back to where I was talking about probate, or with no estate planning in place. Maybe worst of all, your kids would be entitled to all of your assets outright without any restriction at age 18. So my friend's husband received $200,000 when he was 18. And so as a result, he didn't graduate from college until he was over 30 years old and never really learned to support himself financially. So if you have minor children and you want to make sure that they don't receive what you're leaving behind at age 18, you probably want a trust. And like Judy mentioned, you might also want to ensure that your kids receive their inheritance protected from lawsuits against them, from future creditors, or even a future divorce. So, for example, when another one of my friends dad died, I'm sorry, he left her an inheritance, and at the time she was married, So the inheritance came to her outright, and she didn't know how to keep it separate, like Judy was talking about, as a lot of people don't understand how to keep it separate. So, it became commingled in her spouse's bank account. And so when she got divorced, her husband got half of its value. In contrast, if her dad had left her that money in a protected trust, she could have used it to invest in her business, in real estate, and kept all of it when she got divorced. So a trust can ensure that your children's inheritance is protected from lawsuits, creditors, or a future divorce, no matter how old they are. And then before I move on from talking about your kids, if you do have minor kids at home, I just wanted to tell you two quick stories that illustrate kind of where your kids could be at risk, even if you've already named guardians in a will. So if you have not named guardians, as 69% of parents haven't, and something happens to you, the choice about who raises your kids would be left up to a judge to decide. So one quick story. So several years ago, the Barber family, 2 parents, 3 sons, went on vacation in Arizona. They were from California. While they were there, they were in a car accident and both parents died. The boys lived, and when the authorities finally found a family member to pick them up, they found one of the sisters of the mom. And that sister decided that she should get custody of the kids and their money, and prevented them from seeing any of the other family members. And then so after more than $100,000 of court costs and nearly a year of litigation and a huge family fight, a judge decided that a different sister should raise the boys and appointed a financial conservator over the boys' inheritance, the inheritance that was left behind, to a tune of $100 an hour. And then the boys would get whatever was left at the age of 18. So, scary story. So if you would ensure that the people you choose raise your kids in the way that you want, no matter what, I can help you with that. So even if you have a will naming guardians, your kids could be at risk. So I realized this when I was out to dinner with my husband and my 2 little boys were home with a teenage babysitter. I realized that I had named guardians, but they all lived across the country and no one would be able, might not be able to find my will anyway. So at that point, I realized that the authorities would have no choice but to take my kids out of my house and into the care of strangers until they could find my will and locate my named guardians. And then they could make their way across the country. So because this was not acceptable to me, I created a kids protection plan that ensures that no kids are at risk ever from that happening. So I fill in the gaps left by a will only plan. So yeah, I make sure that your kids would never be in the care of strangers with my kids protection plan. And another reason you might want a kids protection plan is if there's anyone in your life who you would never want raising your kids. So a will doesn't exclude anyone from guardianship. So if you know you would never want a certain person raising your kids or challenging your choices, my kids protection plan can also do that. Okay, I will send it back over to Judy.
All right, thank you, Mandie. All right, I would like to mention that not every family is perfect. And sometimes we don't have anybody that we feel confident can handle taking care of the execution of our estate after we pass. That person is who you name as the executor, or we can also call them the successor trustee if it's a trust, and they execute your wishes in the estate plan. If you don't have a loved one, a family member, a really trusted person to name, then there is always the option of finding a professional fiduciary. In California, these people get licensed through the Professional Fiduciary Association, and they're bonded, and they basically are able to take over the trustee or executor duties. I'm going to tell a quick little story here about the Brown family. This is a true story. Clients of ours, that the names are changed, but Bob and Susan Brown have two sons, David and Josh. Josh is married to a woman that Bob and Sharon don't like, Cindy. She's lazy, she's controlling, and she takes advantage and tries to control Josh in any way possible. Now, Cindy and Josh have two small kids. Josh is miserable with Cindy, but doesn't want to get divorced because of the kids. So Bob and Sharon want to make sure that Josh's inheritance won't get into Cindy's hands. Real life example. What can they do? Well, first of all, they found a professional fiduciary. They interviewed about 3 or 4. And again, this is a licensed professional or a firm with licensed professionals who will step in after you either become incapacitated or pass to handle your estate if you don't have a trusted family member to do so. Now, let me just say that they have their other son, but they didn't want to put the sons in any kind of a situation of conflict where one was in charge of the other. So they just decided to have a neutral professional third party named, and this person can spring into action after they pass or become incapacitated. And in addition, to having a fiduciary, you can also have an irrevocable trust drawn up. And I know that somebody had the question that when they registered, how can we make sure that the money doesn't go to the wrong people? Well, or go to our beneficiaries at the times that we want. Well, in an irrevocable trust, you can actually put assets in there that you specify will go at certain periods of time. You can say, well, when my niece is 20 or 30 or 40, they can get the money. So these are specific trusts that guide the fiduciary how and when to distribute assets to the beneficiaries. So those are two possible solutions for when you might need a professional fiduciary. And Mandie, I'm going to turn it back over to you.
Thank you, Judy. Really good points. Is my video on? Okay. There we go. I'm back. That actually, the professional fiduciary, it actually comes up with many of my clients, and it would have actually helped with my situation with my mom. So yeah, very good point. Okay, so I just wanted to go over a few common planning techniques that don't necessarily work. So a lot of people think they can avoid probate by either owning property jointly, designating a beneficiary for their assets, or simply signing a will. So joint ownership has potential problems. So if you remember when you were in escrow on your house, you probably remember that the escrow agent asked you how you wanted to take title to your home. And if you're single, you said, just in your name. If you're married, you said probably joint tenants. So if you took property as joint tenants, you have the benefit of avoiding probate upon the death of the first of you to die. But the downside is that you can't ensure that the surviving joint tenant won't give all that property away to a future spouse or lose all of those assets to creditors. And then designating a beneficiary is an option where assets permit it, but many assets don't permit beneficiary designations. And where you do designate a beneficiary, the beneficiary has unlimited control over the assets. So, and then naming a minor as a beneficiary would just ensure that your insurance or retirement account would end up in court if you died before the kids are 18. So usually the best option is to name the trust as a beneficiary. And as we already talked about, signing a will wouldn't work either. So the only way to keep your family out of court, either in the event of your death or incapacity, is to have a fully funded living trust. So this means you've got a trust prepared that is custom drafted for your family to say exactly what you would want to happen to your assets in the event of your incapacity or death, and that all of your assets are owned in the name of your trust. So even if you already have a trust, chances are it hasn't been updated since you created it, and it's likely out of date because your life has probably changed, the laws have changed, and your assets have changed. And it's also likely that your assets aren't even properly owned in the name of your trust. So when you create a trust, you get to choose how to distribute the assets to your heirs. So they don't just receive the assets at 18, but instead according to a schedule that you determine. So most trusts distribute assets to their beneficiaries at ages or stages. For example, 1/3 at 25, 1/3 at age 30, and the remaining balance at age 35. Or maybe 1/2 upon graduation from college and the balance upon graduation from grad school. So this is an acceptable way to plan, but there's even a better way. So how many of you would like to own assets that can never be touched by creditors, will never be subject to estate taxes, and can never be taken away in the event of a divorce? So if you want to protect your kids' inheritance, this can all be done with a custom trust. And one more thing I wanted to mention, there's currently $9 billion in the California Department of Unclaimed Property. And most of that got there because someone died and their family overlooked an insurance policy, bank account, investment account, or retirement account. So this could easily happen to you if you don't get financially organized and make sure your family knows what you have in the event of your death or incapacity. So we now know what doesn't work. So doing nothing, having a will only, or even getting an estate plan created by a lawyer who just focuses on documents and doesn't ensure the protection of your kids or your assets, doesn't ensure your assets are owned in the right way, and who only addresses financial assets. So for those of you here on the webinar today, I have a special offer. I wanted to give you $250 off of your estate planning if you book your family wealth planning session today or tomorrow. And I promise the process will be much easier than you think. Everyone tells me I make it easy and painless, and it's usually way easier than you thought it would be. So I blocked off a couple dates for family wealth planning sessions for those of you on this webinar. So June 3rd, June 4th, June 7th, and June 8th. And like I said, you get that $250 towards any planning you decide to do. So you can check out my website and let me know what date you like if you're interested. So I will turn it over to Judy now. Thanks again for listening. Hopefully you learned something.
Thank you, Mandie. Such a nice offer. And I'm going to wrap up here with my final couple tips that I want to pass along. One is just about beneficiary designations, and Mandie alluded to that in her conversation with you a second ago. It's very, very important that you review your beneficiary designations on all accounts, life insurance policies, investment accounts, bank accounts, and that be updated regularly. We do a check for all our clients on an annual basis. Definitely, if you have any significant life changes, such as divorce, remarriage, death, a beneficiary death, would be very important as well. And if you have an account that doesn't include a beneficiary, like a non-IRA, you can always list a transfer on death for non-retirement accounts, depending upon the custodian, but most custodians do allow for that. And that's one way to have a beneficiary named on a traditionally non-beneficiary account. And the last thing I'd like to say is that it's very important to assemble your financial team. So our role as investment advisor is kind of a quarterback for a little bit everything. Your insurance professional that can do your property casualty, your home, your health. We do the life and long-term care insurance, but those should be reviewed annually as well. And obviously your estate planning attorney, such as Mandie, and then somebody to take care of your bookkeeping, accounting, taxes, etc. This would make a great financial team. We enjoy working together with our other professionals that our clients work with to ensure a really good result for you. And this is a little bit of how we help in all these different areas. I can send this to anybody who's interested. I see there's a number of our clients on this webinar, so you kind of know what we do. This is our team. There are 5 of us, 3 advisors and 2 staff. And I am also going to offer anybody on this webinar a $350 discount off a full financial plan. And we'd be happy to talk to you about what that would be like. So I thank everybody for joining us. This is actually the final of our 4-part webinar series. So this has been wonderful. And I'll let Robert close us out for the final series.
Great. Thank you, guys. And thank you to all our attendees for signing on and learning about estate planning. So we just have a few questions from the audience that I wanted to ask each of you guys before we sign off. And the first one is to Mandie, and it's, should my trustee of my trust be the same person as the guardian if there are minor children involved?
Oh, good question. I get that one all the time. So I always tell people your guardian should be the person that you want raising your kids. So take the finances out of it, pick the guardian based on how well you think they could raise your kids. So, and then your trustee is going to be the person you trust most with the money, who is financially savvy, organized. The trustee is going to be giving the guardian money for the care of your children. So sometimes that is the same person, but it does not have to be. And a lot of times it is 2 separate people in those roles. So yeah, good question.
Yeah, it makes sense because those can be very different skill sets.
Mm-hmm, exactly.
Oh, pardon my dog. This is live. Okay, next question is for Judy. Question is, should I name minor children as a beneficiary on my IRA or 401k account?
Aha. This is very common. People want to have their children named as beneficiaries. That would be customary to want to leave your estate to your, 2 kids, 50-50, 3 kids, 1/3, 1/3, 1/3. We see that all the time. It can be problematic if your children are not the age of majority. So if they're minor children and you want to name them as a named beneficiary, then you need to list also a custodian who will handle the the money on their behalf. Or you can put the trust if it's a beneficiary pass-through trust, and you can name the trust, and then you don't have to deal with the problem of a minor child being named. Yeah, good question.
Great. All right. Good answer. Well, I think that does it. We are a little past time, so I'd like to wrap up. And for anyone that still would like to view this or share it with anybody that you think would be interested, we will send you an email with the recorded link on YouTube. So thanks again for joining us, and we'll see you next time.
Bye,
Thanks so
everybody.
much. Bye, everyone.